Before we start the discussion, I just want to read out exactly what the Article 7 of China's National Intelligence Law really says. And here it goes. Any organization or individuals should lawfully support, assist and coordinate with the country's intelligence service, and keep secret what they know about the country's intelligence work. So, I want to ask this question: does such an article support the claim that the law requires Chinese companies to coordinate with the government to steal secrets? Edward?
Yeah, you know, it's interesting. I mean, having spent my career here, I mean, I have almost identical education to Mr. Mike Pence, to Vice President Pence. I have a lot of respect for him, same kind of background, come from the same part of the country. Completely misread this law, policy, and regulations. The only difference.
What does it mean, this article?
Well, I mean, it's no different than we would have in the United States. I mean, that the national security should be protected. And in a court proceeding, for example, would be something like this would be heard in camera. That would be kept private. If it was part of Congress, it would be national intelligence, and it wouldn't be made known to the general public. All this is saying is that, you know, China has national security, national public security issues that they need to deal with such a large country and dealing around the world. And all it does is it affords the same kind of, under a civil law context, that they would have in a common law jurisdiction, in my opinion.
It's interesting because the great majority of people who are criticizing this article are treating it as evidence that Huawei might spy on behalf of the Chinese government. Basically only read the first part of the article, which says that any organization or individual should lawfully support, assist and coordinate with the government intelligence work. But don't forget there's a comma, and the second half says keep secret what they know about the country's intelligence work. I understand that it can also be read that if you have your hands on secret information, confidential information, it is your obligation, or either as an individual or as in a company, to keep it a secret, so as, you know, such confidentiality will not be breached. Professor Liu, how do you read the content of this article and the intention, the legislative intention of it?
Well, even the first part has nothing wrong legitimately, because if you read the CISA, which is the Cybersecurity Information Act, Information Sharing Act, published in the United States in 2015, it says very clearly that you know, the government agencies, the three identified government agencies, have access to corporate data based on national security consideration. So, and the companies, of course, is really straddled between their consumers versus the government in consideration of national security, but the companies, by this law, is really alleviated from any recourse within the government jurisdiction. So that can really, you know, mitigate the problem for the company. So therefore, the first paragraph is very clear. This is really the legitimate claim of any national government. If you look at the law in England, it's in many other European countries, it's the same thing. So you cannot really have a digital gangster, you know, playing around. So the second part is even firm to protect the consumer interest in terms of information access, privacy, etc. So therefore, I do not read anything wrong that is really so different to the legislation in many of those developed world.
It's beyond our understanding too, because if the United States has a similar law, how come the Chinese law is being singled out and this clause is being read partially? You know, they only took the first half of the sentence, obviously, and did not care about what it means to have the second part of the sentence.